Okay, Rob Ryder again. Still Tuesday, the last day of January 2012. Book 3, Chapter 20 of the Pleading. Pleadings are the mutual altercations between the plaintiff and the defendant, at which present are set down and delivered into proper office in writing, though formerly they were usually put in by their counsel or by word of mouth in court and then minuted down by the chief clerks of the or I never could say that word. Whence in our old law, French, the pleadings are frequently denominated the parole. Should look up parole, see what that means. The first of these declarations, the count, anciently called the tale, in which the plaintiff sets forth his cause of complaint at lengths, being indeed only an application or exposition of the original writ upon which his action is founded, with the additional circumstance of time and place and when and where the injury was committed. And we may remember that in the King's Bench, when the defendant is brought into court by Bill of Middlesex upon supposed trespass, in order to give the court a jurisdiction, the plaintiff may declare in whatever action or charge him whatever injury he thinks proper, unless he has held him to bail by a special action, which the plaintiff is then bound to pursue, whatever he swore on the back of his writ, the last chapter. All right? So they can charge you with whatever they want to, right? If they can get you to agree you're guilty or not guilty to trespass. So they're using common law and you in the courtroom and you don't even know it. You think it's all statute. No, they got 3 different courts going. And so also, in order to have the benefit of a taking to secure the defendant's person, it was an ancient practice and is therefore still warrantable in the common pleas to sue out a writ of trespass because you've broken into the guy's property for taking the plaintiff's property, and the plaintiff declares in whatever action the nature of his actual injury may require. So you broke in. Now, okay, that's what the action was. Now, what do you require because of that? What happened in the trespass? As an action in a covenant, or in the case of breach of contract or other less forcible transgressions, unless by holding the defendant to bail on a special, the plaintiff, has bound himself to declare accordingly. So if you took the special bail, you have to put down exactly why it is the guy's there. You can't get him for other things. It's the reason that he's on there. And I think that's the one that also means for more than $10. So if it isn't more than $10 and they didn't follow that path, and then there can't be a special bail, and we need to start going back up the line to see where they made their mistake. But in all of these, there's going to be a loophole, that the escape clause for us. And local actions where possession of land to be recovered, or damages for an actual trespass or for waste, etc., affecting land, the plaintiff must lay his declarations or declare his injury to have happened in the very county or place that it really did happen. So in local actions where possession of land is to be recovered, damages for actual trespasses, the plaintiff must lay his declaration or declare his injury. But in transitory actions for injuries that might have happened anywhere, a debt, detinue, slander, and the like, the plaintiff may declare in what county he pleases. And then the trial must be in that county in which the declaration is laid. So that's interesting. Though if the defendant shall make affidavit that the cause of action, if any, arose not in that, but in another county, the court will direct a change of the venue and will oblige the plaintiff to declare in the proper county. So if he's made any kind of affidavits that the cause of action, if any, arose not in that, but another county, then he's obliged to say what the county is. Having ordered all writs to be laid upon the proper counties, this, as judges conceived, empowered them to change the venue if required, and not insist rigidly on abating of the writ, which practice began in the reign of James I. I wonder what it means to abate a writ. So in these last few pieces here is a piece that's escaping me, but I kind of get the drift, right? It's either or. It's always either or. If you haven't done this, you have to do this. If you did this, then you can only do this. And that's where a flow chart, I'm going to have to work on a flow chart. And this power is discretionally exercised so as not to cause or prevent defect of justice. Therefore, the court will not change the venue to any of the 4 northern counties previous to the spring circuit, because there the assises are held only once a year, and at the time of the summer circuit. And it will sometimes remove the venue from the proper jurisdiction, especially of a narrower and limited kind, upon suggestion duly supported, that a fair and impartial trial cannot be had therein. It is generally usual in actions upon a case to set forth several causes by different counts in the same declaration. So that's how it's generally done, so that if the plaintiff fails in the proof of one cause, he may succeed in another, as in the action of the case upon assumption and undertaking for goods sold and delivered. The plaintiff usually counts on or declares first the settled and agreed price between him and the defendant, as that they had bargained for £20. Unless he should fail in proof of this, he counts likewise upon amount of value that the defendant bought other goods and agreed to pay him so much as they were reasonably worth, and then avers that they were worth another £20. And so on in 3 or 4 different shapes, and at last conclude with declaring that the defendant had refused to fulfill any of these agreements, whereby he is in damage to the value. Each count's worth £20. Bargain for £20. That's where that $20 comes in from the Constitution. Because it sounds like they're talking equity there when you're talking about bargaining, buying and selling. And if he proves a case laid in any one of the counts, though he fails in the rest, he shall recover proportionable damages. So whichever ones he gets of those that are listed, he gets £20 for. This declaration always concludes with the words, and thereupon he brings suit, and therefore he proceeds in suit, by which word suit from the following were anciently understood the witnesses or followers of the plaintiff. Therefore he produces witnesses. Oh, good. He's going to do an affidavit, says he has witnesses. I bet you there ain't one. For in former times, the law would not put the defendant to the trouble of answering the charge, so the plaintiff had made out at least a probable cause. But the actual production of the suit or followers is now antiquated, and has been totally disused, at least ever since the reign of Edward III, though the form of it still continues. At the end of the declaration are added also the plaintiff's common pledges of prosecution, John Doe, Richard Roe, which we have observed now are mere names of form. It's the name of a form. Wonder what the John Doe form looks like. Though formerly they were used to answer to the king for the financial penalty of the plaintiff in case he was non-suited, barred of his action, or had verdict and judgment against him. Well, that's interesting. All this stuff is still used. We're just not using it. Or it's available, we're not using it. So at the end of the declaration are added unto plaintiff's common pledges of prosecution, John Doe, Richard Roe, which we have before observed are the mere names of form. Though formerly they were of use to answer to the king for their merricaments. An merricament is a financial penalty of the plaintiff in case he was non-suited, barred from his action, or had a verdict or judgment against him. For if the plaintiff neglects to deliver a declaration for 2 terms after the defendant appears, or is guilty of other delays or defaults against the rules of law, or is guilty of other delays or defaults against the rules of law, in any subsequent stage of the action, he is adjudged not to follow or pursue his remedy as he ought to, and thereupon a non-suit is entered, and he is said to be whatever. So For the plaintiff neglects to deliver declaration for 2 terms after the defendant. So the defendant appears, and he doesn't come forward with a declaration. That's a delay. Or if there's defaults against the rules of law in any subsequent stage of the action, he is adjudged not to follow or pursue his remedy as he ought to. That's going to be a non-suit. He's going to get a merriment, which is a financial penalty. And thus, deserting his complaint after making false claim of complaint, he shall not only pay costs to the defendant, but is liable to the merriment to the king. Well, that would be you. A withdrawal differs from a non-suit in that one is negative, the other is positive. A non-suit is a default and neglect of the plaintiff, and therefore he is allowed to begin to suit again upon payment of cost. But the other one is an open and voluntary renunciation of a suit in court. By this, he is forever loses his action. Yeah, so we want the withdrawal. A discontinuance is somewhat similar to a non-suit, in that the plaintiff leaves a chasm in the proceedings of his cause, as by not continuing the process regularly from day to day and from time to time as he ought to. The suit is discontinued and the defendant is no longer bound to attend, but the plaintiff must bring again by suing out a new original, usually paying cost to his antagonist. Okay, so if they're not doing this daily, regularly from day to day and time to time as he ought to, the suit is discontinued. Another question to ask the prosecutor, the elected prosecutor of your county. Anciently, by the demise of the king, all suits depending in his court were at once discontinued, and the plaintiff was obliged to renew the process by suing out fresh writ from the successor by virtue of the former writ being totally gone, and the defendant no longer bound to attend in consequence thereof. But to prevent the expense as well as delay of attending this rule of law, that by the death of the king no action shall be discontinued, but all proceedings shall stand as good as if the king had been living. When the plaintiff has stated his case in the declaration, it is incumbent on the defendant within a reasonable time to make his defense and to put in a plea, or else the plaintiff will at once recover judgment by default of the defendant. So what is defense? Defense in the true legal sense signifies not a justification, protection, or guard, which is now the popular signification, but merely an opposing or denial of the truth or validity of the complaint. You just got to oppose it, so you don't agree. So if it is the opening of the case of all civilians, a general assertion the plaintiff has no grounds of action, which assertion is afterwards extended and maintained in his plea. For it would be ridiculous to suppose that a defendant comes and defends, or in the vulgar exception of justices, justifies, defends the force and inquiry in one line and pleads that he is not guilty of trespass complained of in the next. Okay, so you can't say you're guilty or not guilty of multiple things. You just oppose the validity of the truth or of the complaint. Therefore, an action is a dower where the demandant does not count any injury done, but merely demands her endowment, and the assize of land where also there is no injury alleged, but merely a question of right stated in the determination of the recognizors or jury, the tenant makes no such defense. I don't know what that means exactly. The writs of entry where no injury is stated in the count. In writs of entry where no injury is stated in the account, but merely the right of the demanded and the defective title of the tenant comes and defends or denies his right. That is, as I understand it, though with a small grammatical inaccuracy, the right of the demanded, the only one expressly mentioned in the pleadings, or else denies his own right to be such as suggested by the count of the demanded. So a writ of entry, where no injury is stated in the account, but merely a right of the demanded and the defective title of the tenant, that's kind of what we want. when you're claiming your body, it may be the writ of entry that the prosecutor gets sued out in chancery. And in writs of rights, the tenant always comes and defends, denies the right of the demandant and his cession, the right and cession of the aforesaid, or else the cession of his ancestors upon which he counts as the case may be, and the demandant may reply that the tenant unjustly defends, denies the demandant's right, and the cession on which he counts. So he's going to say he's got a better title than you do. All of which is extremely clear if we understand by defense and opposition or denial, but which is otherwise explicitly difficult. Okay, well, if they're just saying that they have a better claim than you, and they're calling you a tenant, you tell, well, no, I'm the king, brother. I have the superior title. The courts were formerly very nice and curious with respect to the nature and defense, so that if no defense was made, though a sufficient plea was pleaded, the plaintiff should recover the judgment. And therefore the book entitled or the new tallies at the end of almost every count, or tale, subjoins, or is added at the end, such defense is proper for the demandant to make. So if no defense was made, though a sufficient plea was pleaded, okay, you didn't make a defense, you just pleaded guilty or not guilty, the plaintiff should recover the judgment. You didn't deny the charges. For a general defense or denial was not prudent in every situation, since thereby the propriety of the writ, the competency of the plaintiff, and cognizance of the court were allowed. So just answering the damn thing in that particular court gave the court jurisdiction. By defending the force and injury, the defendant waived all pleas of misnaming. By defending the force and injury, the defendant waived all pleas of misnaming. By defending the damages, all exceptions to the person of the plaintiff. And by defending either one or the other, when and where it should behoove him, he acknowledged the jurisdiction of the court. But of late years, these niceties have been very deservedly discountenanced, though they still seem to be law if insisted on. Okay. By defending the force and nature, the defendant waived all pleas. Remember that. You waive all your pleas. Because one of your pleas is misnaming. I have to look that up, see what it means. If you defend the damages, all exceptions to the person of the plaintiff, and by defending either one or other of the other, when it should behoove him, he acknowledged the jurisdiction of the court. After defense made, the defendant must put in his plea. But before he pleads, he is entitled to demand one in parlance, liberty of speaking, and may have more granted by consent of the plaintiff, to see if he can end the matter amicably without further suit, by talking with the plaintiff, a practice which is supposed to have risen in the principle of religion, in obedience to the precept of the gospel. Agree with thine adversary quickly, whilst thou art in the way with him. And it may be observed that this gospel precept has plain reference to the Roman law of the 12 tables, which expressly directed the plaintiff and defendant to make up the matter while they were in the way, or going to the prorator, one of two official capacities, the commander of the army, elected magistrate. Guess what? You're going to the Chief Justice of the King's Bench. Directed by the plaintiff to make the matter while they were on their way, or going to the thing to use. I don't know what the rest of that is. There are also many other previous steps which may be taken by a defendant before he puts in his plea. He may in real actions demand a view of the thing in question in order to ascertain the identity and other circumstances. So before you put your plea in, he's telling you there's things you can do. In real actions, which is common law, king's bench demand and view the thing in question in order to ascertain the identity and other circumstances. He may crave oyer demand to hear of the writ, or the bond, or other specialty upon which action is brought. That is, hear it read to him, the generality of defendants. See, so you want him to read it to you. The generality of defendants in the times of ancient simplicity being composed incapable to read it themselves, whereupon the whole is entered verbatim upon the record, and the defendant may take advantage of any condition or other part of it not stated in the plaintiff's declaration. So again, there's certain things they have to have in. You have them read it in the record. You point out the error. He's telling you it's going to be there. So oyer, French word signifying to hear, pleading in a prayer mentioned in the court. Party may read into his deed, state of the pleadings of the opposite party, which deed is intendment of law in court, where it is pleaded in. Bouvier, sometimes it just sends you all over. You got to go 4 or 5 definitions deep. I got to look that one up better. I don't know what any of that means. But I do know that in real actions also, the tenant may pray in aid or call for assistance of another to help him to plead because of feebleness or imbecility of his own estate. Thus, a tenant for life may pray in aid of him that has the inheritance in remainder or reversion, and the incumbent may pray in aid of the patron of the ordinary. That is, they shall be joined. Okay. Thus, the tenant for life may pray in aid of him that has the inheritance and remainder reversion. And an incumbent may pray, got to see what the incumbent is, may pray in aid of the patron and ordinary. That is, that they shall be joined in the action to help defend the title. Well, right now your inheritance is being held in remainder and revision by somebody. The way this is written, I'm going to say it's being held by the Creator. I don't know. It depends what an incumbent may pray the aid of the patron and ordinary. Got to look up incumbent, aid, patron, ordinary. Put it on my list. Voucher is also calling upon some person to answer the action that has warranted the title to the tenant or defendant. This we will still make use of in the form of common recoveries, which are grounded on a writ of entry. Beautiful. That's what I needed. That's what I want to do. I want a common recovery, which is a fictitious suit that has a plaintiff nominee that goes into this room where a voucher and a vouchee come in, and your plaintiff nominee and this other guy go into a side room, into a private room, and only one walks out, which means the other one's left the field. You win and get your stuff. A species of action that we may remember relies chiefly on the weakness of the tenant's title, and therefore vouches another person to warrant it. If the vouchee appears, he is made defendant instead of the voucher. But if he afterwards makes default, recovery shall be had against the original defendant, and he shall recover an equivalent in value against the deficient vouchee. So you and this other guy go in, the one guy leaves, so the guy you were suing loses, and then he goes and sues the guy who left. It's all fiction. An assize is indeed where the principal question is whether the mandant or his ancestors were or were not in possession until the ouster happened, and the title of the tenant is little, if at all, discussed. There no voucher is allowed, but the tenant may bring a writ, warranties of deeds, against the warrantor to compel him to assist him with a good plea or defense, or else to render damages the value of the land if recovered against. In real actions also, again, this is common law. Real actions are common law. Brought by or against an infant under the age of 21 years. Okay, in many real actions also brought by or against an infant under the age of 21 years, and also in actions of debt brought against him as heir to any deceased ancestor, either party may suggest a non-age of the infant and pray that the proceedings be deferred till his full age. Or in our legal phrases, that the infant may have his age. Okay, may have his age, okay. And that parole by demurrer, that is that the pleadings may be stayed, and then they shall not proceed till his full age, unless it is apparent that he cannot be prejudiced thereby. Well, yeah, you can't make an infant a grantor in anything. He can't enter a contract. But by some other statutes, the writ of entry, in some particular cases, and in actions ancestral, brought by an infant, the parole shall not demur, otherwise he might be divorced of his whole property, or even want of maintenance till he came of age. Okay, so this is something the infant's doing. In writs of entry, in some particular cases, and in actions ancestral, brought by an infant, I want my ancestral inheritance, the parole shall not demur. So you got to look up parole and demur. They defined parole earlier, I think, as, I can't remember what that was. That was at the beginning of this particular section we're doing. Otherwise, he might be divorced of his whole property and even want of maintenance till he came of age. So likewise, in a writ of dower, the heir shall not have his age. So likewise, in a writ of dower, the heir shall not have his age. For it is necessary that the widow's claim be immediately determined, else she might want a present subsistence, nor shall an infant patron have it while impeded, since the law holds it necessary and expedient that the church be immediately filled. See, they say church, they're talking about your body filled with the Holy Spirit, in my opinion. It is in this stage also of the cause, if at all, that cognizance of the suit must be claimed or demanded. So at this stage of the suit, the cognizance of the suit must be claimed or demanded. When any person or body corporate has the franchise, not only holding pleas within a particular limited jurisdiction, but also of cognizance of pleas, and that either without any words exclusive of other courts, which entitles the lord of the franchise, whether any suit that belongs to his jurisdiction is commenced in the courts of Westminster, do demand the cognizance thereof, or with an exclusive words, which also entitle the defendant to plead the jurisdiction of the court, or with such exclusive words, which also entitle the defendant to plead the jurisdiction of the court. So you can plead the jurisdiction of the court. Upon claim of cognizance, if allowed, all proceedings shall cease will cease in the superior court, and the plaintiff is left at liberty to pursue his remedy in the special jurisdiction, as when a scholar or other privileged person of the University of Oxford and pleaded the courts of Westminster for any cause of action whatsoever, unless a question of freehold. In these cases, by the charter of those learned bodies confirmed by Act of Parliament, the Chancellor or Vice-Chancellor may put in a claim of cognizance, which, if made in due time and with due proof of the facts alleged, is regularly allowed by the courts. It must be demanded before and in parlance, and that's where you guys go in a room together, the private room on the side. For that is a submission to the jurisdiction of the superior court. Okay, so if you go into an parlance, you are submitting to the jurisdiction of the superior court. That's not all bad. And it will not be followed if it occasions a failure of justice, or if an action be brought against a person himself who claims the franchise, unless he has the power, in such case, of making another judge. Unless he has also a power in such case of making another judge. So we're talking about franchises, as some of these courts are franchises. I have to read that more later, but let's go on. When these proceedings are over, the defendant must then put in his excuse or plea. pleas are of two sorts, dilatory and pleas of action. Dilatory pleas are those who tend merely to delay or put off the suit by questioning the propriety of the remedy rather than denying the injury. Pleas to the action are such as disputed the very cause of the suit. The former, the dilatory, cannot be pleaded after a general imparlance, which is an acknowledgment of the propriety of the action. Dilatory pleas to the jurisdiction of the court alleging that it ought not to hold plea of this injury is arising in Wales and beyond the sea, or because the land in question is of ancient demise. Dilatory to the jurisdiction of the court. Alleging that it ought not to hold a plea of this injury, it arising in Wales or beyond the sea, or because the land in question is of ancient demesne and ought only to be demanded in the Lord's court. To the disability of the plaintiff, by reason whereof he is incapable to commence or continue a suit, as that he is an alien enemy, outlawed, excommunicated, attainted of treason or felony, under a forewarning, not in the nature of things, being only a fictitious person, an infant, a femme covert, a monk professed. So these are the different kinds of dilatory fees. Please, let me move this down here. In abatement, which abatement is either of writ or the count of some defect in one of them, okay? Some defect, as in misnaming the defendant, which is called a misnomer. Remember that. Giving him the wrong addition as Esquire instead of Knight. If they put Mr. in front of you, so I'm not a Mr., I'm a king. A Mr. is a military term. It could be a term of nobility, too. I think that's what we need to look at it in this case, is terms of nobility. Or it may be that the plaintiff is dead, for the death of either party is at once abated of the suit. Well, there you go. He's dead. And in actions merely personal, arising from wrongdoing, for wrongs actually done or committed by the defendant as trespass, battery, and slander, the rule is that a personal action dies with the person, and it shall never be revived either by or against the executors or other representatives. So, if we're supposed to be dead in their courts, we know they are. They took an oath. I don't know exactly how to put that in words yet, but, it's good for the goose is good for the gander. For neither the executors of the plaintiff have received, nor those of the defendant have committed, in their own personal capacity, any manner of wrong or injury, but in actions arising from contract by breach of promise and the like, where the right descends to the representative of the plaintiff, and those of the defendant have assets to answer the demand, though the suits shall abate by the death of the parties, yet they may be revived against the executors, being indeed rather actions against the property than the person, in which the executor have now the same interest in that their testors had before, testators. These pleas to jurisdiction, to disability, or abatement were formerly very often used as merely dilatory pleas without any foundation of truth and calculated only for delay. And we got a statute that says no dilatory plea is to be admitted without affidavit made of truth, therefore, thereof, or some probable matter shown to the court to induce them to believe it's true. And with respect to pleas themselves, it is a general rule that no exception shall be admitted against a declaration or writ, unless the defendant will, in the same plea, give the plaintiff a better, that is, show him how it might be amended, and that there may not be two objections upon the same account. And that there may not be two objections upon the same account. That sounds important. I have to ponder that. All pleas to jurisdiction conclude to the cognizance of the court, praying judgment, whether the court will have cognizance in the suit. Pleas to the disability conclude to the person by praying judgment if the said A, the plaintiff, ought to answer the pleas of abatement when the suit by original conclude to the writ or declaration by praying judgment of the writ or declaration, and that the same may be quashed, made void, or abated. But if the action be by bill, the plea must pray judgment of the bill and not of the declaration. The plea being here the original, and the declaration only a copy of the bill. All right, so we got to do the plea must pray judgment of the bill and not the declaration. The bill being the original. So what did the bill say? That's what we want to go by. Judgment of the bill. That's your plea. How do you plead? Judgment of the bill. When these dilatory pleas are allowed, the cause is either dismissed from the jurisdiction or the plaintiff is stayed till his disability is removed, or he is obliged to sue out a new writ by leave obtaining of the court or amend and new frame his declaration. But on the other hand, they are overruled as frivolous. The defendant has judgment to answer over in some better manner. It if then incumbent on him to plead a plea of action, that is to answer the merits of the complaint. That is done by confessing or denying it. So there's a plea you can do, a plea to action. Got all sorts of pleas. A confession of the whole complaint is not very usual, for then the defendant would probably end the matter sooner, or not plead at all, but suffer judgment to go by default. Yet sometimes, after tender or refusal of debt, if the creditor harasses his debtor with an action, it then becomes necessary for the defendant to acknowledge the debt and plead the tender. And it had always been ready, and still ready, to discharge it. For tender by a debtor, for tender by the debtor and refusal by the creditor will in all cases discharge the cost, but not the debt itself. Though in some particular cases the creditor will be totally lose his money. All right. So he's using the word tender. You know, I didn't go to Bouvier to see what tender is, but I will be. But frequently the defendant confesses one part of the complaint, acknowledges the action in respect thereof, and traverses or denies the rest. So you acknowledge one part. Somehow they get you to acknowledge it, but not the rest, in order to avoid the expense of carrying out part of the formal trial, which he has no grounds to litigate. A species of this sort of confession is the payment of money into court, which for the most part necessarily upon pleading a tender, and is itself a kind of tender to the plaintiff, by paying into the hands of the proper officer of the court as much as the defendant acknowledges to be due, together with the cost hereto incurred, in order to prevent the expense of any further proceedings. This may be done upon what is called a motion, which is an occasional application to the court by the parties or their counsel in order to obtain some rules or order of the court, which become necessary in the progress of the cause, and it is usually grounded upon an affidavit, the perfect tense of the verb affidio or assidio, being a voluntary oath before some judge or officer of the court to evince the truth of certain facts upon which motion is grounded, though no such affidavit is necessary for payment of money in court. So you don't have to do the affidavit if you're going to pay the money in court. This is where you're going to get them. What was this? The governments of the civilized world have caused them to be manufactured in certain portions and marked with a stamp which attests to their value. This is called money. Oh, that was whatever money is. Would have caused them to be manufactured. So the governments of the civilized world have caused them to be manufactured in certain portions and marked with a stamp, which attests to their value. This is called money. That's what money is. For many purposes, banknotes, checks, negotiable notes will be so considered. Credit and account in the books of a third person or any chattel is sufficient and will be treated as money. So you have credit and account in the books of a third person. So you can say, I'm going to pay it on my credit. If after money paid in, the plaintiff proceeds in a suit, it is at his own peril. For if he does not prove more due than is so paid into court, he shall be non-suited and pay the defendant cost. But he shall still have money so paid, for that defendant has acknowledged to be his due. So I believe, and this applies to the $20 limit in the Constitution. If you're not there in front of a jury, right, the suit has to be less than $20. In the French law, the rule of practice is grounded upon principles somewhat similar to this. For there, if a person be sued for more money than he owes, yet he loses his cause if he does not tender so much as he really does owe. So they can sue you for more than you owe if you don't pay them out you do owe. So you have to ask them. That was up here. What's your plea? Where did that go? A plea and plead the tender. Oh shoot! There's the phone. Hang on a second here. Well, we're good. To this head may also be referred to the practice of what is called set-off, whereby the defendant acknowledges the justice of the plaintiff's demand on the one hand, but on the other, sets up a demand of his own to counterbalance that of the plaintiff, either in the whole or in part of. If the plaintiff sues for £10 due on a note of hand, the defendant may set off £9 due to himself for merchandise sold to the plaintiff. And in the case he pleads, such set-off must pay the remaining balance in court. This answers very nearly to the stoppage of the civil law and depends on the statutes which enact that where mutual debts between plaintiff and defendant, one debt may be set against the other, and either pleaded in bar or given evidence upon general issue at the trial, which upon shall operate as payment and extinguish so much of the plaintiff's demand. Okay? Think about that. Pleas that totally deny the cause or of complaint are either general or the general issue or special plea in bar. The general issue or general plea is what Traverses Swartz denies at once the whole declaration without offering any special matter whereby to evade it, as in trespass by force of arms, not guilty, in debt of contract, not debit, he owes nothing, in the debt of bond, not made of the, is not his deed. Okay? In the debt of bond, not his deed. On the assumpt, he made no such promise, or in real actions, no wrong done. No decising in writ of right, and the tenant has more right to hold than the demandant has to demand. These pleas are called general issue because by importing an absolute and general denial of what is alleged in the declaration, they amount at once to an issue, by which we mean a fact affirmed on one side and denied on the other. Formerly, the general issues were seldom pleaded except when a party meant wholly to deny the charge against him. But when he meant to distinguish or set apart, away or lessen without curing the charge, it was always usual to set forth the particular facts in what was called special plea, which was originally intended to apprise the court, the adverse party, of the nature of the circumstances of the defense, and to keep the law, in fact, distinct. So, right, you're going to establish the facts in a special plea, and it is an invariable rule that every defense which cannot be thus specifically pleaded, may be given in evidence upon general issue at the trial. But the signs of special pleading having been frequently perverted to the purpose of cheyenne and delay, the courts have of late, in some instances, and the legislature and many more, permitted the general issue to be pleaded, which leaves everything in the open, the fact, the law, and the equity of the case, and have allowed special matter to be given in evidence of trial. Have allowed special matter to be given, special, that which relates to particular species of matter of kind, matter of substantial, essential thing opposed to form, facts. Special matter, so special facts to be given as evidence in trial. And though it should seem as much confusion and uncertainty would follow from so great relaxation of the strictness anciently observed, yet experience has shown it to be otherwise, especially with the aid of a new trial, in case either party be unfairly surprised by the other. The appeal. Special pleas and bars of the plaintiff demand are very various according to the circumstances of the defendant's case. As in real actions, a general release or a fine, both of which may destroy the bar of the plaintiff's title. Or in personal actions, an accord, arbitration, condition performed, nonage of the defendant, or some other fact that precludes the plaintiff from his action. A justification is likewise a special plea and bar, as in actions of assault and battery, that the plaintiff's own original assault, in trespass, that the defendant did the thing complained of in right of some office, which is warranted of him to do so, in an action of slander, that the plaintiff is really as bad a man as the defendant says he was. Also, a man may plead the statute, limitations and bar, or the time limited by certain acts of Parliament beyond which no plaintiff can lay his cause of action. In a writ of right is 60 years. In a seize, writs of entry, and other possessory actions real, of the size of one's ancestors and lands, and either their size or their own, and rents, suits, and services, 50 years. In an action real in actions real for lands grounded upon one's own size or possession, such a possession shall be made within 30 years. Okay, so we got different time lengths here. But, of course, another statute, at time of limitation was extended in the case of the king, so that possession for 60 years precedent ever against prerogative or degradation of the ancient maxim, no time runs against the king. 20 years is the time limitation for any writ, form of gift, and by consequence 20 years is also limitation of every action of ejectment, for no ejectment can be brought unless where the leaseor or the plaintiff is entitled to enter lands. So you could only give a lease for 20 years. And if they're coming after you after that, well, they can't do it, apparently. No entry can be made by a man unless within 20 years after his right shall occur, unless you're the king. As to the personal actions, they are limited by statute, late mentioned in 6 years after the cause of action commenced, except actions of assault, battery, mayhem, imprisonment. Okay, so we have statutes of limitations. And informations upon penal statutes where the forfeiture is to the crown shall be sued within 2 years, and where forfeiture is to a subject within 1 year after the offense committed, unless there are any other time as specifically limited by statute. Lastly, no writ of error, show cause, can be brought to reverse any judgment, fine, recovery, error, unless it be prosecuted within 20 years. The use of these statutes or limitations is preserve the peace of the kingdom to prevent those innumerable perjuries of which might ensue if a man were allowed to bring an action for an injury committed at a distance of time. The past, well, I wrote that in. Past the past, leave it there. Both upon these accounts, the law therefore holds that the public good requires an end of litigation, and upon the same principle as Athenian laws in general prohibited all actions where the injury was committed 5 years before the complaint was made, and therefore in a suit the injury or cause of action happened earlier than the period expressly limited by law, the defendant may plead the statute of limitations and bar as an assumpt, or promise to pay money to the plaintiff, may plead non-assumpt. He made no such promise within 6 years, which is an effectual bar to the complaint. Well, there you go. If you didn't make the promise within the last 6 years, then it's is an effectual bar to the complaint. An estoppel is likewise a special plea and bar, which happens when a man has done some act or executed some deed which estops or precludes him from averring anything to the contrary, as if a tenant for years, who has no freehold, levies a fine to another person. Though this is void as to strangers, yet it shall work as estoppel to the cognizor. For if he afterwards brings an action to recover these lands, and is fine pleaded against him, he shall thereby be estoppel from saying that he had no freehold at the time, and therefore was incapable of levying it. Okay, and there's a definition of estoppel. As you can see, I'm not really 100% sure on this stuff myself, but I'm just telling you what I've read so far. Let's try to fill some holes in. The conditions and quantities of the plea, or qualities of the plea, which are as well the doctrine of estoppels, which hold equity, equally, mutualist, mutinous, which regard to other parties and pleadings, that it be single, containing only one matter, for duplicity begets confusion. A man will with leave of the court, may plead 2 or more distinct matters on a single pleas, as in an action of assault and battery, these 3 not guilty, son assault demise of his own assault, and statute of limitations. That it be direct and positive, not argumentative. That it have convenient certainty of time, place, and persons. That it answer the plaintiff's allegations in every material point. That it be so pleaded as to be capable of trial. So I guess if you're going to use evidence, make sure it's foolproof evidence so that it's capable of trial. Special pleas are usually in the affirmative, sometimes in the negative, but they always advance some new fact not mentioned in the declarations. And then they must be averred to be true in the common form. And this he is ready to verify. This is not necessary in pleas of general issue, those always containing a total denial of facts before it advanced by the other party, and therefore putting upon him the proof of them. It is a rule in pleading that no man be allowed to plead specially such a plea as amounts only to a general issue, or to totally deny, or a total denial of the charge, but in such case he shall be driven to plead the general issue in terms whereby the whole question is referred to a jury. But if the defendant, if in an assize or action of trespass, be desirous to refer the validity of his claim title to the court rather than the jury, he may state his title specially and have at the same time give color to the plaintiff or suppose him to have appearance of color or title, bad indeed in point of law, but of which the jury are not competent judges, as if his own true title be that he claims a feoffment in livery from A, by force of which he entered on lands in question, he cannot plead it by itself, as it amounts to no more than a general issue, in assize or not guilty in an action of trespass. Okay, but if a defendant in assize or if you're a defendant in an action of trespass, you refer to the validity of his title to the court, he may state his title specially, and at the same time give color to the plaintiff, or suppose him to have appearance of color or title, bad indeed in point of law. And then in record, they'll have a trial by record and see whose record is better, who has the title. But he may allege this specially, provided he goes farther and says that the plaintiff claiming by color a prior deed of feoffment without livery entered upon whom he entered, and may then refer himself to judgment of the court which of these two titles is the best in point of law. Okay, I'm going to run short of time on this, so I'm going to stop here and have to finish up on a second one. So it'll be a short one, but I only got 5 minutes left, and it's going to take a little longer than that. So there'll be a 4B also. We'll see ya.